Today, wicked dealings. The DFA daily to the 30th of June 2021. Hello again, it's Martin North from Digital Finance Analytics. Welcome to the latest posts covering finance and property news with a distinctively Australian flavour. Today we'll look at how Congress is pushing for regulation of cryptocurrencies, how Greensill Capital sold future receivables, and how NAB sent out as many as 69,000 defective fee statements from its wealth management division. Firstly, in the US, many in the cryptocurrency industry have long demanded that Congress provide regulatory clarity on how it will tax and regulate digital assets. But as powerful figures in Washington weigh in, it's doubtful that crypto enthusiasts are liking what they hear. Democrat-Republican Bill Foster of Illinois, co-chair of the House Blockchain Caucus, said on Tuesday that laws must be passed to allow federal courts to identify digital asset holders and then reverse transactions in Bitcoin or other digital currencies. Now that's a policy that's an anathema to many cryptocurrency investors. You have to be able to go to a court to unmask participants under some circumstances, Foster said during an Axios virtual event on Tuesday, adding that cryptocurrencies must be pseudo-anonymous so the regulators can see if the transactions on the network are fraudulent. Different cryptocurrencies exist on a continuum of anonymity. Bitcoin, for instance, is largely anonymous, even as every transaction on the network is public for anyone to investigate. However, there are methods of discovering someone's real-world identity by studying this transaction history and searching the internet for instances where a Bitcoin user may have accidentally linked their Bitcoin wallet address with personal information. It's possible, for example, for a user to send his wallet address along with an email signature that includes personal information like a name or phone number. Foster suggested new laws should require a different form of pseudo-anonymity, wherein a court, that is, a third party, could learn the real-world identifier of a cryptocurrency user through a very heavily guarded key. Foster argued such tools are necessary for the government to protect itself, American businesses, and individuals from ransomware attacks like the one used to extort millions of dollars from Colonial Pipeline, an incident that led to widespread gasoline shortages last month in the US. I've just said about 3 things there that will drive the crypto purists berserk, like the trusted third party and so on. But in fact, there's not a technological alternative that I'm aware of, Foster said. For most people, if they're going to have a big part of their net worth tied up in crypto assets, they're going to want to have that security blanket of a trusted third party that can solve the problem. Many in the cryptocurrency industry have argued that no government can actually prevent its citizens from buying and selling Bitcoin or other cryptocurrencies that provide varying degrees of anonymity. For instance, Chenzhe Zhao, CEO of the world's largest crypto exchange, Binance, said at the recent CoinDesk Consensus 2021 virtual conference that I don't think anyone can shut it down now, given that this technology, this concept, is in 500 million people's heads. Just a few weeks later, the United Kingdom restricted use of the exchange within its borders, but the impact of that move on crypto use in the UK remains to be seen. Foster continued that cryptocurrencies must become compliant with federal regulations and laws for them to ever become mainstream instruments for conducting transactions. We're going to have to establish a law between the legal and illegal regimes here, Foster said. There's a significant sentiment, increasing sentiment in Congress, that if you're participating in an anonymous crypto transaction, then you're a de facto participant in a criminal conspiracy. Elsewhere, Greensill Capital founder Lex Greensill has revealed some $15.7 billion of assets sold by the collapsed supply chain finance company in 2020 were, quote, future receivables that were mostly passed on to Greensill Bank. The UK's Treasury Committee, which has been holding hearings into Greensill Capital's demise, late on Tuesday, released a letter from Mr. Greensill containing a table showing 11% of Greensill Capital's $142.9 billion in asset flows, or $15.6 billion, came from future receivables in 2020. Almost 3/4 of the 2020 future receivables were sold to Greensill Capital's Greensill Bank in Germany, which is being investigated for alleged balance sheet manipulation, with the remainder sold to other investors. In 2018, just 2% of the company's $27.3 billion in asset flows came from future receivables. Mr. Greensill said the future receivables program offered to clients were fully disclosed to investors, but Mr. Greensill reiterated the supply chain finance group never issued any documents referring to prospective receivables. The term prospective receivables is unknown to Greensill Capital and does not appear in any client or investor documentation ever issued by the company, Mr. Greensill said in the letter. Greensill Capital offered future receivables programs to clients, and the nature of these future receivables was fully disclosed to investors. British politicians last month questioned Mr. Greensill on the concept of prospective receivables. US coal miner Bluestone Resources, which is suing Greensill Capital, has alleged in a lawsuit that the company agreed to finance it based not on the existence and collectability of Bluestone's then existing receivables, but rather based on Bluestone's long-term business prospects. The defined term receivables includes so-called prospective receivables, Bluestone said in its lawsuit. GFG Alliance boss Salvia Gupta, one of Greensill Capital's biggest clients, also said in a letter to the Financial Times on April the 7th that many of Greensill's financing arrangements with its clients, including with some of the companies in the GFG Alliance, were prospective receivables programs, sometimes described as future receivables. As part of these programs, Greensill selected and approved companies with whom its counterparties could potentially do business in the future, Mr. Gupta wrote. Greensill then determined, at its discretion, the amount of each prospective receivables purchase and its maturity. Mr. Greensill declined to provide the committee with a copy of an insurance policy that he said would pay out on fraudulent loans, arguing it was confidential. The Treasury Committee also released a letter from BCG Trade Credit Director Toby Guy and former UK Prime Minister David Cameron. BCC Trade Credit, owned by Japan's Tokyo Marine, was one of Greensill Capital's biggest insurers, but refused to extend some policies beyond their March 1st, 2021 expiry date. Mr. Guy said that BCC and Tokyo Marine had by July 2020 and throughout the rest of 2020 developed particular concerns about Greensill, which made them very reluctant to provide any cover. All rights under and in relation to any and all policies purportedly issued by BCC to Greensill have been reserved by BCC since that date, Mr. Guy said, and Lex Greensill seemed unworried in the face of a long and rigorous interrogation. Gupta is unlikely to find a buyer for beleaguered Wylands Bank, the CEO said, and other concerns as to the structure and placement of the purported insurances are also developing, and in this regard our investigations are ongoing. Mr. Cameron, who was a senior advisor at Greensill Capital, said he did not believe Greensill Capital's business was at risk of failing in 2020 and did not become concerned it was in financial difficulty until he received a telephone call from Mr. Greensill last December. but he said he was aware the concentration of loans from Greensill Capital to GFG Alliance was an issue for the business, one that was discussed at board meetings. My understanding was that it was being actively managed and dealt with by the company appropriately, and that there were plans in place to reduce the concentration over time, Mr. Cameron wrote. And Mr. Cameron said that he never wrote to the Prime Minister Scott Morrison about Greensill Capital, but confirmed he used the company plane a handful of times on a personal basis. And again elsewhere, a former NAB employee has apologised for the conduct that meant 6 out of every 10 statements issued to the bank's wealth clients between 2013 and 2018 was defective, as the bank prepared to bring the long-running saga to a close. The apology is contained in a federal court affidavit written by the former acting managing director of MLC and Financial Services Council board member Andrew Morgan, who took the reins from Jeff Lloyd late last year. In a statement dated May the 28th, Mr. Morgan accepts that the bank, which sent out as many as 69,000 defective fee statements, had let down its wealth clients by failing to deliver correct statements on time and in line with its obligations. NAB deeply regrets that the contraventions occurred, and NAB is mindful that its behaviour has fallen short of what the broader community expects, Mr. Morgan wrote. On behalf of NAB, I wish to extend sincere apologies to our clients and all persons affected by the contraventions, the court, as well as the broader community. Mr. Morgan left the business 3 days later following the sale of NAB's wealth business to IOOF, and he'd been acting managing director of wealth for 6 months and joined the bank last year. He was paid £516,000 last year. The affidavit is part of a broader effort to bring to a conclusion a multi-year stoush with the corporate cop over failures that became known as the Fees for No Service scandal and were explored during the Hayne Royal Commission. During the hearings, it emerged the bank sought to minimise its offending by cherry-picking numbers bound for the regulator that would place the bank in the middle of the pack. Financial services institutions have repaid customers almost $1 billion in the aftermath. In an outline of submissions filed on June the 5th, 2021, the corporate regulator argued that senior members of NAB's management team were on notice from at least 2013 of problems with systems relating to the charging of ongoing fees. A supplement to the document contained a chronology of events that showed the non-provision of service was one of the 3 most complained about issues among NAB's wealth clientele in a report dated August 2012. Almost a year later, in May 2013, MLC's head of risk and compliance would note the problem of advisors charging ongoing service fees, however, no ongoing service provided, before concluding, it is expected that this issue will resolve itself. The bank filed a breach report with ASIC on December the 20th, 2013, where it acknowledged that the law requires that ongoing fees are not charged if the FDS has not been supplied. However, it did not turn the fees off until more than 5 years later. The Australian Securities and Investments Commission ultimately ambushed the bank with a court action on the eve of its 2019 AGM. NAB confesses to faulty disclosures, misleading and deceptive conduct, and in an agreed statement of facts issued almost 18 months later, the bank admitted to 670 breaches of the Corporations Act and 1,615 breaches of the ASIC Act for false and misleading conduct. However, ASIC abandoned the fee for no service part of the case. The two parties are still some way apart, with NAB arguing a penalty of $50 million would be appropriate, putting forward a formula that included $8 million in fines for the Corporations Act breaches and $7 million in fines for the ASIC Act breaches In ASIC's submission, it explained that despite the offences containing a theoretical maximum cumulative penalty of $3.17 billion, the figure was not appropriate. Instead, it has arrived at a fine of $71.5 million with discounts for contrition and cooperation, bringing the proposed fine down even further to just $40 million, cheap at half the price. I'm Martin North from Digital Finance Analytics. Many thanks for watching, and I'll see you again next time.